A group of state lawmakers now want even more restrictions on abortions in South Carolina. So a measure dubbed the Prenatal Equal Protection Act would now ban the procedure starting at conception. If passed into law, House Bill 3537 would make it so unborn children are defined as persons, meaning an abortion could then lead to a murder charge, even for the mother. Lawmakers also heard public comment on both the new abortion ban and legislation that would make it a crime to possess drugs that can then be used to induce an abortion. Opponents to the bills now argue that restrictions on certain drugs limits access to quality health care. Let's bring in Chief Legal Analyst Khalifa Rose to talk about all this. I mean, the big question, Khalifa, I have is how can South Carolina apply homicide laws from conception when the 14th Amendment doesn't recognize a fetus as a legal person?
I think they can't. 3537, I think, is dead on arrival. Even if it unlikely passes in South Carolina because Republicans control both chambers, I think it would be absolutely destroyed for constitutional issues if it ever goes to the Supreme Court. Anyone challenges this, even this rendition of our Supreme Court that has been extremely open to widening and lengthening opportunities to, enhance anti-abortion laws that have been implemented in states. I think this one would be a step too far, and the Supreme Court would likely strike this down as unconstitutional. You mentioned the 14th Amendment. They've talked about things like this in other states a number of times late last year. I doubt that it would have the traction to make it out of South Carolina, but if it does and someone has standing to bring a claim before them, a parent that wants to end the pregnancy, a doctor that feels like they aren't able to provide the care they need for a person because of something like this that limits their ability, I think it would be a easy case in front of the U.S. District Court, U.S. Court of Appeals, and then ultimately in front of the Supreme Court.
So how would prosecutors then distinguish a criminal act from a miscarriage and also preventing the wrongful charges against women?
I don't know. I mean, that's something that I think is going to be behind door number one. It's a surprise because anytime you have new law, you're trying to figure out a different way to prosecute it. You know, we have, revenge porn type of laws that were newly implemented, and you're trying to figure out, well, how do you prosecute those? Death by distribution, new laws for trying to figure out how you prosecute these. But in this specific incident, you're going to have to go after, this will have, I'm assuming, be a specific intent crime. So you would have had the intent to kill the fetus. And so a miscarriage would be outside of that intent. However, the prosecutor may be able to point and connect the things that you did, even if it wasn't taking some type of abortion medication that you led to or walked yourself into doing that, which then ultimately could give you some type of prosecution. So I think this is going to open up not just Pandora's box, but a slippery slope for prosecutions against mothers that are just trying to have a child, and or women that have complications with child and legally would be able to have an abortion under this heartbeat law that has been revised last year.
So what federal laws then would kind of collide with all this, like whether it's HIPAA violations or anything else, to be able to, even the mother that is traveling for medical care?
I don't know if there would be any federal impact in terms of with this law, because if you think about it, Supreme Court kicked all of this to the states. So the states would be able to, in their own rendition, come up with abortion laws that they feel that would be able to govern their state. It just has to make sure that it's constitutional. And so the only federal law I would think is the 14th Amendment, but nothing in terms of the distribution of drugs across state lines, in any type of interstate commerce, none of that would come into play. What would directly be on point is this a violation of my constitutional rights? And I think it would be to the person carrying the child. And I just think that the Supreme Court would strike this down. That's why other states that talked about it, like Louisiana, for instance, would have removed and walked away from this type of thought process since last year.
Khalifa Rose, appreciate your insight. Thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.